Alex here with part 43 of the My Docket series on child custody and visitation. As with my previous videos, I'd like to take this opportunity to direct my viewers to part 0 if you haven't seen it yet. That is the video that contains the detailed disclaimers and the underlying purpose of the series. Two things that I will glaze over are, number one, I'm not in the middle of this right now. My case is completely and totally over. It's closed. It cannot be reopened, and my ex's parental rights have been terminated. Number two, the nutshell version as to the explanation of the purpose of the series is to give my viewers one big example of my 8-year-long high-conflict child custody ordeal from beginning to end in chronological order. We left off in part 41 with my filing of a motion, and the purpose of the motion was to force my ex to agree to a procedure for setting appointments, non-emergency appointments. She had this opinion quite a few videos back that she was going to set all appointments, and I had no purpose in setting appointments because I had no purpose in going to appointments. Her own words were that I was only entitled to provide emergency care, and any non-emergency care, that was all hers. And after I ended up winning a pretty big motion, which was the main request in that one was for her to turn over the medical benefits cards, she continued to take this position. And what's really weird is that her attorney went along with it. I'm kind of surprised that her attorney didn't sort of chastise her, saying, hey, you tried this, you lost. Let's not do this again. It's going to get, it's not going to be good. But she does, she tries again. She files an opposition, and that's pretty much the whole, topic of this video. And I don't really have a whole lot more to go into with regards to my mindset, because I went into it pretty thoroughly with part 41, both prior to and during the discussion as to the motion. And so in this video, I think we can straight away go right into what my ex's attorney has filed. Here we have the opposition to my motion that my ex's attorney has put together. The first paragraph, as per usual, she introduces my ex, and she introduces herself as the one representing my ex. She also mentions that she is opposing, well, she doesn't actually put the full title and the date that I filed that motion. That's a little odd. Usually they do that, and for my viewers, I'd recommend you do that. You want to name the motion that you're opposing, as accurately as possible. You don't want to just say plaintiff's motion, because I filed so many motions. And you also typically will mention the date, just in case it's one of those things that there are multiple filings with the same title. And in fact, even if there aren't, it kind of helps the judge to just, go straight to that date, or the law clerk, whoever it is that's actually reviewing it. And they can more quickly find the motion that you're referring to. So she's saying here that I did not cite legal authority, asking for an unwarranted procedure. This is actually a valid opposition if you want to speak in the very technical sense. When you make a request, you should include points and authorities, and you shouldn't just call them points and authorities. You should actually include citations to the law and to the court rules. So my ex's attorney is correct with regards to this. Don't make the mistake I did. This does not end up backfiring on me. The judge does not hold this against me. And that's because, it's a family case. If you try to do this in another type of case, it's not a good idea. Don't do that. Not to say that I did that on purpose. I just had no idea that that was that big of a deal at this point. And it's funny to say that, because I've been representing myself for at least a year, and I still haven't figured that important detail out. I eventually do figure out the importance of statutes, rules, and case law. It's not just sort of icing on the cake. It's the actual, the meat of the motion or the opposition, whatever it is you're filing. It's very important to have it. So she brings this up. She uses it against me. It doesn't actually end up working. The judge just ignores it. And many family judges will just ignore something like this. However, I do still want to, I don't want to just glaze over and act like what she's saying is ridiculous, because it's not. It's a very valid point. The court rules require points and authorities and affidavits, and you must include points and authorities and affidavits. You want to play it safe and follow the rules. Don't just wing it and hope that the court's going to cradle you. And in this case, like I said, it's not a big deal. The judge doesn't even mention it, but I still want to tell my viewers that this does matter. The other thing that I want to mention is that her argument is actually potentially damaging to her own client, because I'm not sure that there is any authority for my judge to set a procedure. I don't think that there is. And it's possible that he can't really enter a procedure. I've never really thought about this in detail. I've always wondered about orders like this. A lot of judges enter them, but I've always wondered, is there really any authority for them to do that? Now, I mentioned earlier that it's kind of, it sabotages her own client, and I'm going to go ahead and explain what I mean. If there is no way for the court to give recourse in the way that I'm requesting, what does that mean the court has to do? The court doesn't just walk away and give you nothing. The court has to solve the problem. A child is suffering and relief is required. So if the court lacks the authority to set a procedure, then the court needs to fall back and the court needs to fall back on authority that does allow it to take action. And one of those things that the court can do is deprive my ex of legal custody. So if this judge was in a snarky mood, he could have, had my ex's attorney walk in and said, "Hey, you're right. There is no way for me to do this under the law. I cannot set this procedure. Unfortunately, I'm going to have to do what the law does allow me to do, and I'm going to have to deprive your client of legal custody." So that could have potentially blown up in my ex's face had the judge taken this argument seriously. And I think, honestly, it would have been better for our son to just take her legal custody away right then and there, because he does end up suffering a lot more after this. He ends up requiring 5 crowns and 2 extractions because of the damage that is going to continue to persist, because the court's not going to take action until way too late. But the court does not do this. He ignores my ex's attorney's argument, and he will set some kind of procedure. I can't remember the details of it. And the conflict will continue. But it's just one of those things that, ironically, yeah, she's right. I didn't bring up any points and authorities because I don't think there are any. However, well, I guess this is where you would say ironically. Ironically, the conclusion there isn't better, it's worse. It's not that you win, it's that you end up losing a whole lot more. So let's scroll down. Parties share, joint legal, joint physical. So this is a summary paragraph. Mentions the age of our child, names him. She's saying that I have access to our son's physicians and I can contact them directly. I have the capability of looking things up on the internet or in the phone directory. So she's actually justifying her client not turning over information. That's fun. Yeah. So she's saying I don't need to have any information because I can just look it up myself, just based on having their names. This doesn't really solve the problem of me getting to go to appointments, though. This is just me getting information. So this is still a very messed up response. I've requested that my ex provide me with a copy of our son's birth certificate, even though I could get one myself at Vital Statistics. Oh my God. That's so bad. See, there's so many red flags here, and my judge just does not take action. So she's saying I don't need to get a copy of the birth certificate because I can go get one myself at Vital Statistics. Okay, that's going to take a while. First off, it's not going to be like right away that I get that. And second off, that's not free. So all she has to do is run it through a copier and give me a copy of it, and she won't do it. I think she does the same thing with his social security number. She's saying that I'm using every means available to contact her unnecessarily. I could buy that if she actually did turn over these documents and I kept communicating with her. But that's the thing, she's not turning them over. So there are high conflict people that will do that. They will use every means available to find an excuse to contact their ex, just to stress them out. They don't actually really care what it is that they're communicating about. But in this case, this isn't true. I want to mention something because a lot of unscrupulous attorneys will do this. You should see the video Win at All Costs, because it goes into the tactics that most attorneys use, which is to win at all costs. And one of those tactics is to paint you out to be something that's very common. And the reason they do that is because they know that the court is less likely to actually look into it. If they claim that you stabbed your child with a knife, the court's going to look into that. But if they claim that you're a vexatious litigant because you're representing yourself, most judges don't look into that because it's such a common thing. So many people who are representing themselves harass and annoy their ex with filings. And so when they accuse you of something that's very, very common, the judge typically will just take their word for it. Same thing here. A lot of these high conflict exes will find any reason that they can to communicate with you. And so this attorney is using that same tactic. She's just accusing me of doing what most of these other people do, hoping that the judge doesn't actually look into any of it. And he just assumes because so many people do that, then I probably am doing it too. And this is one of the reasons I think that her attorney is able to prolong the agony for so long, because she really knows how to read the judge, how to dupe the judge. The judges kind of become a machine after a while, and the attorneys pick up on it. They get used to the patterns and the tendencies. And so the attorneys will start to adapt. And if they notice that they're able to deceive the court in a certain way, and it works, they'll continue to do that. So what she's doing here is not all that uncommon at all. A lot of attorneys will do this. Unscrupulous attorneys will do this. And again, if you want to learn more about why they do this, you should watch the video Win at All Costs. Next paragraph here. I have been notified by her of the following appointments. So she's saying she told me about the December 4th, this November 30th, November 18th. What is she talking about? I've never responded to the notifications. I'm interested here to see my reply. Maybe these were the ones that I was talking about in the previous video that I mentioned that she gave me a last minute notice on. I am skeptical though, because I kind of feel like that didn't come up right away. I feel like that came up after a court order. So, I don't know. I think I'm going to have to take a look at my reply to see what my response is, because this is 10 years ago and I just can't remember. But she's alleging here that she is telling me about appointments and that I'm not responding to them, which I highly doubt. Let's see here. In fact, the last appointment, I caused him to be a no-show because I refused to return him to her. She was charged a cancellation fee. I can't wait to see what my response is to all this stuff. This is ridiculous. Next, we got August 26th. I have never taken him to a physician or urgent care while he was in my custody, and she's been the only one to take him when he's sick, and my strategy is to return him to her rather than taking him for medical care, and that's also ridiculous. Next, we've got further evidence of my non-cooperation and attempts to harass her when I refused to bring him to an exchange location, which required her to call. Oh, I love this. I remember this. So she's saying that I refused to bring him to an exchange. What really happened is my car broke down. And I do not have to explain this because you're going to get to see it in a video. And what I will say is this, it backfires on her big time. The judge blows up on her about this particular exchange because she essentially lies to the court. She says that I didn't show up because I didn't feel like it. And then when the truth comes out and he realizes that she called the police and wasted everyone's time, including his, he kind of blows a gasket. So this is going to be coming up in one of the videos. Very soon there will be a hearing video where we will get to see this exchange between my ex and the judge, and it's not pretty. To protect herself, she's obtained a fictitious address. She starts to use this fictitious address pretty much any time that she can. And I don't want to spend a lot of time on this because I'm going to end up suing the government and winning. What I'm going to say in a nutshell is she takes advantage, her lawyer is taking advantage of, you could think of it as a loophole. The confidential address program requires that you show you are a victim of domestic violence to get a confidential address. But there is a problem. There is a subsection in that statute that says to get a fictitious address, you need to provide one of the following documents. And one of those documents is an order of protection. The problem is there is another statute that says to get an order of protection, you only have to show the potential for domestic violence having occurred. So what her lawyer did was exploit that loophole. And I've talked about this in the past with incompetent legislatures that don't actually pay attention to what they're doing, and they'll pass two statutes that contradict each other, and it creates all this confusion. This is why I ended up winning that lawsuit against the government. And you'll find out when I get to that point in my Docket series. It's not going to come until I think around 2012, 2013. But I do eventually bring this to the Supreme Court's attention, and the Supreme Court agrees with me that those two statutes are not consistent. You can get a protective order by just showing a potential, and you can only get the confidential address if you are actually, a victim. So what my ex's attorney does is she exploits this, and she basically dupes the judges into thinking she's an actual victim for a little while. But they eventually do figure it out, and this is, as I mentioned in many of my previous videos, this sort of deception is ultimately what leads to the termination of her parental rights. It's not on its face what causes it, but it's her recalcitrance, her resistance, of letting that issue go even after she's lost, even after the government's lost the lawsuit, even after I sued her using the publication. it's going to end up coming about, but this is something that you're going to see throughout the series. She's going to continue to use a fictitious address to deceive the court and to think she's an actual victim. For the most part, this judge doesn't buy it, but some of the other ones that get involved kind of do, because they just don't know what's going on. They also are ignorant as to any of the details. So we're going to scroll down here. Okay, wait, she's citing my petition for judicial review. She's saying that I'm trying to strip her of the fictitious address. Okay, I might have missed this video. So what I'm going to end up doing is holding this video and then publishing that piece so that my viewers don't get this all out of order. So you're going to end up watching this video when that video has already come out. And I'm just realizing this just now because I'm reading this document. So sorry about that. But it's all going to be in order as to how it's published. But this little snippet here is a little bit off because I'm forgetting that I filed that petition for judicial review. So I'll get to talk about that a little bit more in that specific video. And I'll probably renumber this video to part 43 of the My Docket series. But anyway, I'm going to go ahead and move on because I've already started this video. The courts admonished me that I shouldn't bring... Okay, I don't want to talk about this because it's going to yellow flag the video. If you want to know more about this next part, please watch part 30 of the My Docket series. The judge addresses it very thoroughly. I'm going to continue moving on. Behavior shows length at which I will go to contact her. That's also not true, but it's just what she's saying. Next we have schedule suggested unnecessary, that I have not gone to any appointments. So she's basically saying that what I'm saying is not true and therefore I shouldn't be allowed to go to any appointments. She's saying I'm not going to any appointments now and everything I'm alleging isn't true, so I should just continue to not be allowed to go to any appointments. Anybody who's been practicing family law that has scruples would know that this is a really messed up position to take. But for some reason, my ex's attorney goes along with it. And that's one of the things that I've talked to a lot of lawyers about that they don't really understand. There's certain things that a lot of lawyers just won't do because they don't want to look that bad. But this lawyer doesn't seem to mind. And a lot of times the judge just kind of goes along with it. I'm not sure why he does. Next paragraph here. It says that I didn't attempt to resolve the matter, and so she should get an award of attorney fees. And this is a ridiculous request, and I'm able to fend it off pretty easily. I'm going to address it more when I get to my reply to opposition. But if you want to know more a little bit about how I do this, watch my video, Defend Against Attorney Fees. She's saying that the court enjoys discretion to award attorney fees and costs post-divorce, which isn't, like, we're not married. This is not a post-divorce action. So that's not true either. We're unmarried. This is just a child custody case. Also, prevailing party doesn't get attorney fees in child custody cases. This thing is just full of baloney. Here we have instant case. I'm continuing to file motions without seeking first to speak with my ex's attorney to resolve the matter. I don't think this is true. I'm pretty sure at this point I do start to send emails to her. But even if it is true and I'm filing motions without communicating with my ex's attorney, that's not really what the court requires. You're required to communicate with your ex. And even that isn't actually required officially. That's still not a basis to give fees unless you're in the 8th Judicial District Court. And if you are, you should watch my video. The duty to, I think it's requirement to attempt resolution, something like that. I have a video called Requirement to Attempt Resolution, and there's a local rule in Clark County, also known as the 8th Judicial District Court, that requires you to actually try to work something out. And if you don't, it specifically says in the rules that you can be sanctioned with an attorney fee award. I still want to mention, even though it's not a rule in 2nd Judicial, it's a good habit to get into. It's a really good habit. So even if there's not a rule forcing you to do this, you should do this. For the foregoing reasons, she would request that the court deny my request and assess me the cost of a no-show. I don't think that ever happens. Next we have certificate of mailing. As I've mentioned before, this little certificate is what keeps her from having to file that separate affidavit of service that I keep filing. And here we have the motion opposition notice. She's checked the boxes, and according to the check marks, she does not have to pay a filing fee. Here we have my ex's affidavit, which is in support of the opposition. It basically swears under oath that everything that's alleged in the opposition, everything factually that's alleged is true, under penalty of perjury. And here we have a petition for exhibits. Let's go. We have 3, so I'm going to just really quickly glaze through these. Of course, as with my previous videos, you can find this document down in the links. You just click on it, you can download it, take a look at it, and ask me more questions if you have detailed questions. But I don't like to spend too much time on these. It's just, communications back and forth. A lot of times it's argumentative. So this one says, I'm communicating with my ex to please send me a social security card and birth certificate. I don't mind if it's mailed or if I have to pick it up or if you enclose it with child support. Oh, at this time she was paying me child support. Well, she's going to be paying me from now until the end. This doesn't change. The amount changes, though. If the cost is exceeding $2, I'm not authorizing it. Well, it is 2 pieces of paper. But if you want to print it from your home, you can just count the copies as 20 cents. The reason I'm saying this here is because she would find excuses to not provide stuff to me. So I'm kind of hedging in advance. I'm like, hey, if you're going to say you don't want to pay for it, I'll just give you $2 for 2 pieces of paper. Please don't resist or a motion will be filed. This isn't really deemed to be a negative thing to the courts, but there's a way to word this better. It's still going to be used against me even if I did word it better anyway. If I would have filed a motion and I worded this really nicely, flowery words and stuff, I would have still been attacked. But you should still try to resist saying something like, I'm going to sue you or file something against you. Even though you're going to do it, say something more innocuous like, this is really important to me and I'm hoping we can work it out. And then if it doesn't work out, file something. It just looks better. A lot of times attorneys will take little lines like this and show it to the judge and say, look, he's a bad person. Give me attorney fees. Just don't give him any extra ammo. And here we have, this is my petition for judicial review that I filed. So I'm going to end up having gone through this already, so I'm going to skip this. And here we have, looks like her response to me. I'm, by the way, filing something instead of going to the lawyer with a proposal is not going to work with her. The judge ordered you to try to work things out. She does the FYI thing a lot. And then she has the day off tomorrow, so if I'm planning on dropping him off without telling her, then I should think twice. Dropping him off to a babysitter's without telling her. She will be able to take him all day long. Oh, so this is the beginning of the what is it called? This is the beginning of the right of first refusal wars. So what she's saying here is that since she can take him, she wants to take him. She doesn't want him to go to a sitter. And this ends up becoming a war that goes on for years and years about right of refusal, with her saying that we do have it, with me saying that we don't have it. I do give her some opportunities to watch him, and then she just uses it against me in court. One example is I wanted to go on a vacation. I said, hey, if you want to, you can watch him. I have a sitter. If not, she said, no, I'll watch him. She watches him. Then when we go to court, she says, hey, he dumped the kid off on me when he went on a vacation. So she makes it look like I said, you better take him because I'm going to just leave him. And so that's kind of like the beginning of the end of right of first refusal, because I'm like, why am I going to go through this when you're just going to weaponize it? And here we have another affidavit. This one's unsigned. Well, it's probably because the first one was signed. That's a little odd. Going into the aftermath, I didn't file anything. I incurred $0 in costs. My ex's attorney filed a free document, so she incurred $0 in costs. I didn't have an attorney, so I incurred $0 in attorney fees. My ex's attorney would have probably spent a good hour, I think, in preparing that document. She herself probably had a paralegal prepare it. She also would have had to communicate with my ex about what she expected to be in the opposition. There were some details in there, some dates. An hour might be a bit light, but I am erring on the conservative end with these videos, so I think it's fair. So let's go ahead and call that $250 in attorney fees. And if you have any questions, as with my previous videos, feel free to post something down in the comments below, and I will see you guys next time.